Okay, when you're selling, those of you selling under consignment, make sure you understand where it falls under Article 9 and the secure transaction provisions. Years ago, consignment fell under Article 2A leasing. That changed 20 some years ago. It now falls under Article 9. In order to have priority rights over a previous secure interest with your consigned goods, you must now comply with the same rules that apply to a purchase money security interest in inventory. Because, my agreement says, my consignment agreement says that I retain title to my consigned goods. I know they're consigned goods. My customer knows they're consigned goods. The problem is nobody else knows that. And that's the issue with consignment and why they put this in. The writers of the Article 9, the writers of the Commercial Code, they deemed this to be a secret lien for exactly that reason. If potential lenders coming in behind us that do a search, there's not a filing out there to let them know that these consigned goods don't belong to the debtor. They belong to me as the consignor. So we have to do all the things that we would need to do with a purchase money security interest in inventory. We must get a consignment agreement signed, we must file a financing statement, and we must do a search and notify all previously secured parties with our consignment arrangement. And if we do not do that, and a bank has filed a UCC against that debtor, which typically is the case, the bank is going to have first rights in our consigned goods ahead of us. So we want to avoid that. We don't want that happening. You want to make sure, the courts have been very consistent. If you do not do your PMSI UCC filing in a consignment situation, you do not have priority rights in your consigned goods. So please make sure you do. Additionally, make sure that you know exactly how these things are recorded, how they're searched for, and how they're going to come up in situations where there's a default. And that's the key. If there is a default by the debtor, if there's a bankruptcy, the trustee is going to do a search in the correct jurisdiction using the standard search logic of that jurisdiction. Whatever comes up during that search is a correct UCC filing, and whatever does not, in all probability, is going to be determined to be seriously misleading, and therefore they are not secured in the way that they believed. So the key here is standard search logic, and this is where it gets a little problematic. You can imagine 50 different states mean 50 different computer systems and 50 different standard search logics. So the way these systems look for things and the things that come up in those searches are going to vary from one state to the next. And it can get idiosyncratic. Periods in the debtor name can make a difference. Inc. versus incorporated can make a difference. So you do want to make sure, A, you have the correct legal name according to the Articles of Incorporation, and B, that you understand how those states are going to be searching and what comes up under those states.